but offers are being accepted. That, you know, there's deal sheets are being sent out. So, you know, hopefully that gives you a little bit of energy, a little bit of excitement to take on this week and take on the rain that's coming by us. Alan, any quick words before we handle?
No, I think with what's going on out there, it's all about trying to keep touching your clients. And I think this topic that Jordan's speaking about is pretty neat because it gives you an opportunity to converse with your clients, give you a reason to speak to the clients. So I think what Jordan has to say is going to be very positive. I guess without a further ado, let's get Jordan to talk a little bit about this great topic.
Okay, I'm unmuting myself. First of all, and what might be helpful, everyone, is if you go to the upper right-hand corner and you see there's a little box there that says Speaker View, maybe click on over to Speaker View, because I'm going to try to, at least for some part of the presentation, share my screen so you can see the PowerPoint, which I think has already been circulated, but just a little easier for me to talk and go through it at the same time, and I'll go in and out of that. Let me just get us into.
And also, if you have questions, the chat box, everybody knows about a chat box by now on the bottom. So feel free to interject as we go along.
Yeah, go ahead and send those questions. We've got a bunch already queued up, and you know, as additional questions come, we'll get to them all either during or at the end of the presentation. So let me just see. Hold on, wait. I think
that's perfect.
Yeah. Let's see if I can share the.
I asked a question already, Andrew.
June, that's real estate. You're gonna have to hold off with that.
Okay. Well, I was just reacting to your comment about all the contracts, the deal sheets you saw that came in this week.
Does everyone see my PowerPoint? What do you see? Yeah, you see the PowerPoint there?
Yep.
Do you see me as well? Does
yep.
It show? Oh wow, this is
best of both worlds.
Technology is wonderful. Okay, all right, guys. So you know, first of all, the new normal, right? This is my family home in quarantine. My 14-year-old's birthday was the other day. You can see the candy cake there in front of him, which is why I'm happy that nobody has to wear pants right now. It's a pretty it's a lot of eating going on. So you know, this new normal brings with it a lot of different things. You know, this is a time where the real estate market hopefully is speeding up again, but it's been slower, and it gives us a good opportunity to take some time to increase our level a little bit and be able to learn new things and have new topics to talk to our clients about in the real estate world that ups our level, that ups our game. And these are the things, some of the things that I'm going to cover today. I'm going to cover a lot of high-end stuff that, you know, don't normally discuss with a real estate group, but I would normally discuss with a group of accountants or a group of attorneys. But this is good technical stuff that sophisticated real estate owners know about, and they're thinking about it, and they want to know more about it. So you being able to converse about these topics is a real advantage for you to distinguish yourself and be able to add more value than they might have ever expected, because you can come out of left field and offer them just enough estate planning information, just enough you know, additional technical knowledge that can prove to be very useful to your clients in the future. And this helps you to speak their language. So this is very high-end info, but we're also going to cover some of the basics, and then we'll get into some of your questions. And as I said, we already have a bunch of questions already queued up, so we'll be ready to go. Okay, so the first question, and something that I'm dealing with a lot right now, before I even get into any of the sophisticated estate planning topics, are estate sales during quarantine. You know, there are a lot of deals that come across where the seller is an estate. I anticipate, you know, based on the fact that you know, people are passing away from COVID, because the surrogates courts right now, as I'll mention in a bit, are basically closed. That we're going to have a big buildup of estate issues. So it's important to kind of check back in and make sure that we understand who has the authority to sell a property where the owner is now deceased. You know, a lot of times families will get together after someone has passed away and they'll say, yeah, we want to sell grandma's apartment, and let's go get a broker and we'll get the listing going and we'll start showing the apartment. We'll sign a contract. And that's kind of putting the cart before the horse, because we've got to make sure that somebody has legal authority to sign your listing agreement. If they don't have legal authority and they go ahead and sign it anyway, it's not great for you, because you could be investing a lot of time and energy in trying to market and sell an apartment. And then this person that signed your agreement doesn't have the ability to consummate a sale. They don't have the ability to sign a contract. Now we first have to start dealing with administering the estate and getting someone appointed as a legal representative. So very important to make sure that we understand that, and that we you know, temper our enthusiasm a little bit and make sure that when an estate deal comes in, that we're confirming that someone has legal authority to act. A lot of misunderstandings around power of attorney, and that's important for everyone to understand. A power of attorney is only good while the principal, the person who gave the power of attorney, is still alive. So if that person has passed away, the power of attorney is no longer valid. So if somebody comes to you and says, my grandma passed away and I want to sell her apartment, and I have her power of attorney, so I have authority to sign, they don't. And we still are faced with that estate issue. So now understanding the situation with the surrogates court. Whenever you have a will has no legal effect until it goes through this process called probate, which you've all heard of. And probate requires that a petition and other documents be filed with the surrogates court in the county where that person lived, and that the court vet through that process, and then they are willing to issue what we call letters testamentary, or letters of administration if someone died without a will, granting someone the authority to deal with that property or that apartment, that condo. And that process is basically at a standstill right now because the surrogates courts are not accepting new petitions. I heard a rumor the other day that they would consider accepting non-contested petitions. I haven't confirmed that yet. It was just a rumor. The official word is that the courts are not accepting any, which means the fact that the courts have been refusing petitions for a month and a half to 2 months, the day that court opens up, they're going to be buried with new petitions that the court is going to have to administer. So even in a simple situation where you have to deal with the surrogates court, at its best, it's like dealing with a DMV. And now they're even more overworked and understaffed. You know, it normally would take maybe a month to get letters of administration or letters testamentary if everything was lined up and everything was simple. Now it may take much longer than that. I really don't know what they're going to do. So the first thing you'll want to do if a new estate deal comes through the door is you can start laying the groundwork, start getting the family prepared to, you know, clear out the apartment and get it ready to show, but also get them started with that process so that, you know, I have 5 estates right now sitting with petitions ready to go. And the day I hear that the surrogates court is open, I'm going to rush in with my petitions and try to get them to the top of the pile. So you want to make sure that your people are doing the same, because if they come in a week after the surrogates court's open, those petitions are going to a bottom of a very big pile. This issue also reinforces the usefulness of trust planning. You know, we're often advocating the idea of taking property and placing it into a revocable trust in order to avoid probate. You hear people talk about revocable trusts or living trusts as a means to avoid this probate process, which, as we've already established, is a bit of a pain in the neck. So if someone owns property, they've placed it into a revocable trust during their lifetime, and they pass away, even in a situation like this, we don't have a problem selling that property right away, because the property doesn't belong to their probate estate. It has no place in the surrogates court. It already belongs to a trust. The trust already knows who the successor trustee is. It already knows who the beneficiaries are, and we can just go right ahead and sell that property. So a very good idea, and this kind of bolsters the argument for why people should want to avoid probate and avoid having their estates be at the mercy of the calendar of the surrogate's court. Another thing, topic that you're probably hearing a lot about is the governor's executive orders, which have enabled us to do a lot of things while the courts are closed, while we're not able to sit down with clients based on social distancing, to sign, notarize, and witness estate planning documents via virtual conference calls like this one. So I find myself on Zoom 3 or 4 times a day, not only conducting meetings with clients, but just before this, had a will signing with a client where we had a client in one window and their witnesses in 2 other windows and me in the other. And we're sitting there and we're going through the documents. The witnesses are watching and everyone gets their documents signed up. So we were never able to do that before. You always needed to have 2 physically present witnesses, unrelated witnesses in the room, and now we're able to get all of that done virtually. So it's a big help, and we've been able to do a lot. And that's also helpful, where people, I've had a lot of calls from people where they're panicked that they might be starting to feel sick, they're home, they're worried, what if I have to go into the hospital, I need a healthcare proxy, I'm concerned, I want to make sure my will is right, and we're able to do everything virtually, again, which is very helpful. So now on to the more technical stuff. There are some underlying concepts that I want everyone to understand, which will make the rest of the presentation make more sense. The types of clients that we're dealing with here, for the most part, that are dealing with these higher end real estate planning strategies are high net worth people. These are people that own, townhouses and expensive condos. They've got a house in the Hamptons. They've got, extensive stocks and bonds and company business, family businesses. And they have estate tax issues. But who has estate tax issues? That's the part that I want everyone to understand. I'm gonna flip forward on the slide for a second, and then we'll come back. This is an illustration of the estate tax exemption and where it kicks in. And you can see that, starting in 2011, we had a $5 million federal estate tax exemption and a $1 million New York estate tax exemption. That exemption means that if you had assets above and beyond that amount, you have estate taxes. This is starting in 2011 is a big number. When I started practicing 21 years ago, the federal estate tax exemption was under $1 million. So many more people were affected by the federal estate tax. And for many, many years, the New York estate tax was $1 million or less. The federal number started to go up. And now you fast forward to the highlighted line, you can see right now in 2020, the federal exemption is almost $12 million per person. And the New York exemption is almost $6 million, which sounds like a lot, and it is. And with a married couple, you can basically double that exemption for either of those amounts. And as long as their estate planning documents are correct, we shouldn't have estate taxes unless we're above and beyond that number. But number one, that requires that they have correctly prepared estate documents. Number two, we've got that issue that you see right below that highlighted line, which is that, when the Tax Cuts and Jobs Act was passed in 2017, they were only able to make this increase in the federal exemption temporary. So at the end of 2025, which is not too far away, that exemption is set to come back down by about half. So a lot of high net worth clients are now concerned that, well, I'm not intending to die before 2026, and I'm worried that this exemption, I have it now, but I may not have it in the future. What can I do to preserve it? So there's a lot of planning going on right now where clients are using their exemptions to fund trusts and make irrevocable transfers while the exemption is high, because they've already received guidance from the IRS that if you use it now, it won't be clawed back later, which is a huge thing. So you're seeing different strategies employed where people have estate tax liabilities, or they would expect to have estate tax liabilities if the exemption goes back down to $6 million per person, and they want to make sure that they're locking in use of that almost $12 million exemption today. So then, that's the federal tax. The New York state estate tax is a bit of a trap, because although the exemption is just under $6 million, the problem that you have is first of all, if you don't have properly drafted estate planning documents and you're a married couple, you could very easily end up blowing it and not using the first exemption on the first death, and therefore only having $6 million between you as an exemption rather than the $12 million which you were allotted. So you need to have proper documents in place in order to make sure that you're taking advantage of the full 12. But even if you do, the issue with the New York exemption is if you go over it by more than 5%. So if it's 5.9 million and you have 6.3 million, you're taxed as if you had no exemption at all. You're basically taxed on the first dollar that you have. So it results in a tax that's much higher than one would anticipate if you significantly exceed 105% of the New York exemption. And that's a big problem. So, we're often dealing with situations where it's someone that doesn't necessarily anticipate having a federal estate tax due on death, but the New York estate tax, by the way, 16%. The federal estate tax is about 40%. So you can see very quickly if someone is of high net worth, their exemption may not go a very long way, and they can end up with millions upon millions of dollars of estate tax. So this is why this stuff is so important. Also, another thing that I want everyone to understand, just as the kind of the baseline, is the tension between estate taxes and income taxes. When I own a piece of property and I leave it to my heirs receive a step up in basis if they inherit it through my estate to the value of that property as of my date of death. So if grandma bought a building in Brooklyn 25 years ago for $1 million, and now that building, the area has changed, it's a very hot spot right now, and that building is not worth $1 million, now it's worth $10 million. If grandma leaves me that building in her will and she passes away and I inherit it, I get a $10 million basis in that property. Now, there may be some estate taxes to pay, but I get a $10 million basis. So I turn around the next day, I hire my real estate agent, we sell the property for $10 million, and now I don't have any capital gains tax to pay because I received that step up in cost basis. The alternative, and you see this a lot, and unfortunately it's a big mistake in some cases. Grandma bought the building for $1 million. Now it's worth $5 million. She doesn't want to deal with lawyers. She doesn't want to deal with courts. And she thinks the best thing to do is just put my kids' names on the property now so that I don't have any issues with my estate later. So she goes ahead and she has her real estate attorney prepare a deed, transfers ownership of the property to her children, and now she passes away. She had a $5 million estate, so she did not have any estate tax liabilities for New York or for federal purposes. But what she did was she made a gift during her lifetime, which gives the children her basis in the property rather than the stepped up basis. So now they turn around, the real estate agent does a good job and sells the property for $5 million. And now they've got to report capital gains on $4 million worth of gain. If she would have just left that property in her estate and let the children inherit it through her estate, they would have received a $5 million cost basis and they would pay no capital gains tax. So it's very important that you understand those dynamics. So if you're able to intervene and stop a client from making a multi-million-dollar mistake, I think they'll greatly appreciate it. So always understanding that if we're talking about some type of plan where we're advocating a gift, that gift may have income tax consequences, and we've always got to have an analysis to evaluate what we're gaining and what we're giving up whenever we do any significant estate planning. So obviously nobody should run off and start gifting things away without the advice of their attorney and their accountant. Okay, so we talked about carryover basis and step up in basis. Also, in evaluating that, consider the fact that the federal estate if someone has a federally taxable estate and they live in New York and they've got, you know, a combined 50% tax rate on property in excess of that exemption, I'm not as worried about capital gains tax treatment, right? Because 20% versus 50%, I'd rather pay 20% tax than 50%. So if you don't have a taxable estate, there's often not a good reason to make gifts, or taxes are obviously not a good reason, and you end up putting yourself in a bad situation by making unnecessary gifts. So again, you know, these things should be carefully considered and shouldn't be done just because someone feels that probate is a bad idea. We can avoid probate, but yet still get that step up in basis if we do things properly. So just keep that in mind. Okay, the credit is unified. So where I say someone has about a $12 million federal exemption, that's an exemption they can use during life by making gifts, or at death and having that exemption applied toward their property at death. There are different ways of using that credit. You know, an outright gift of cash is probably the worst possible thing to give away, because cash has a very definitive value. There's no way we can discount it. There's no way we could argue it's worth less than it is. A dollar is worth a dollar. Where we're dealing with a piece of real estate, or more accurately, where we're dealing with an investment and we're dealing with an entity that holds a piece of real estate, we've got all different opportunities to discount the value of that property. And that's what's so attractive to a real estate investor in doing their estate planning. We can take a piece of property that is worth $10 million, and because we're giving away a minority interest in that property, because the shares that we're giving or selling don't have the ability to vote, or you couldn't sell it to a third party for fair market value, we're able to discount the value of that, say, by 35%. So when we hire a valuation company to assign a value, we're using up less exemption than dollar for dollar. So we're able to get more bang for our buck. We're able to transfer more property out of someone's taxable estate and potentially save them millions of dollars in estate tax by applying these discounts and these different estate planning strategies, which I'll talk about. A strategy that's probably on the simpler side, something that you might have encountered in the past, is something called a QPRIT, or Qualified Personal Residence Trust. That's a trust for someone's property that they occupy. It's not for a piece of investment real estate. It's for their primary home or for a vacation home. And that enables us to transfer that real estate into a trust and apply some level of discounting and get that property out at a discounted level and freeze the appreciation. So we're also always looking for hot real estate, right? We're looking for a piece of property that we expect will explode in value. That's the time, before it explodes in value, is the time that we want to plan with it. Because if we can take a piece of property that's not, you know, the rents are low, you know, we've got to age out of some under market rents. You know, the area is up and coming, but it hasn't come up yet. If we can take that property at its present day value, discount it, get it out of someone's estate, put it into a trust for the benefit of their children, and then all of a sudden it explodes in value, and it would have been worth 5 times as much in their estate, but now all of that growth has grown tax-free outside of their estate. That's a home run. That's where, you know, a high net worth client is really going to appreciate the value added there, because it's real millions of dollars of value added. So where we're talking about a residence, we're talking usually about a qualified personal residence trust for estate tax planning. When we're talking about investment real estate, we're talking about typically something called a GRAT, or a intentionally defective grantor trust. I know that's a mouthful, but you may have heard about that. And I'm going to go into each of those strategies in a little bit more detail here. So as I mentioned, the qualified personal residence trust is typically involves the transfer of someone's residence. So let's say we're dealing with a client that has a $10 million property in the Hamptons that they use as a second home. And it's one of their larger assets. They clearly have a taxable estate because as it is, they have a home that's worth $10 million that's in New York. They've got New York estate tax at a minimum, probably federal tax too. So what can we do about that piece of property? How can we allow them to continue to maintain it and live there, still leaving the door open if they want to sell it in the future? But how can we get that property out? Because let's say it's worth 10 million, but we think the market's kind of low right now. Things aren't moving as quickly as they were. The market is, we can get a favorable valuation here. So it's favorable at 10 million, but we really think that ultimately this property is worth 15 million or more. We can create a qualified personal residence trust where I transfer my interest in my residence to the trust, and I reserve the right to live there for a number of years. So I say, okay, I'm 45 years old. My life expectancy, let's say, is to 85. So I could pretty much pick my term. I'm going to say I reserve the right to live in this property for 20 years, but I'm irrevocably transferring it into this trust now with my right to live there for 20 years. As long as I can survive that 20-year term, that's why I say you must survive it. I can take a discount on the value of that $10 million property based on the fact that I'm not giving away the property for another 20 years. So if I said, you can have my house, which is worth $10 million, but you can't have it for 20 years, it's certainly not worth $10 million because you're going to have to delay the use of that property for 20 years. So we're able to deeply discount what we're giving away and use up less exemption, get that property out of my estate at a $10 million value. And by the time I pass away, not only does it not belong to me anymore, so it's not included in my estate, but I gave it away at a $7 million value. And by the time I die, now it's worth $15 or $20 million. That's an estate planning home run. So it provides us with a value freeze and also a discount opportunity. Someone can do that with up to 2 residences. The only caveat here is these types of trusts actually work better in a high interest rate environment because you're able to get bigger discounts. In a low interest rate environment like it is right now, those discounts are not as deep, but it's still a valuable thing. And it's also a valuable planning strategy for people who are concerned about liability. So where someone says, I want to live in my home, but I want to protect it against my creditors because I feel that I'm in a business where I'm likely to be sued. And I want to get that asset out of my name, and I don't want to put it in my spouse's name. I just want to, lock it up and keep it protected. That's a side benefit of doing these types of trusts because I reserve the right to live there for 20 years. Then I put into the trust that as long as my spouse is living, my spouse has the right to live there for the rest of her life. So as long as my spouse is alive and I'm allowed to live with my spouse, nothing changes for me. I get the discount. I get to live there for the rest of my life. I don't have to pay anybody any rent, but I've gotten all of that benefit of the freeze in value and the discounting. And then if my wife leaves me or she passes away and I still want to live there, I reserve the right under the trust to rent the property back from the trust for fair market rent, which is not necessarily a bad thing because if I'm a high net worth person, I'm looking to get rid of money, I can pay rent to this trust that's for the benefit of my children. I'm basically paying money to my children. And the way we write these trusts, and this is the real trick, because these trusts are written in a certain way, they're considered to be me for income tax purposes. They're called what we call grantor trusts. So because that trust is considered to be me, if I'm paying rent to myself, I don't have to pay income taxes on it either. So there's a lot of aspects to this, but it really can be a big advantage to someone that's got ultra valuable residential real estate that they live in. And keep in mind, it can still be sold. So if the person decides, I don't want to live in that house anymore, their trustee can go ahead and sell that property, substitute in the next piece of real estate, and we can just continue that term and continue those provisions without a hiccup. So it doesn't limit them in terms of locking down the property where they can't sell it, but you're providing a tremendous service to them if you're able to at least advise them a little bit that this opportunity is available and maybe it's something that they should be looking into. Let me move on to the next. The grantor retained annuity trusts, GRATs. I know you've heard these acronyms thrown around a lot, and you may have some understanding of what they are. But a grantor retained annuity trust is something that I would do with a piece of investment property, either investment real estate or an operating business, where I'm exchanging an interest in this asset for an annuity. So I will take a 20% interest in my apartment building in the Bronx, and I will sell it to this trust in exchange for an annuity. Now, because I'm transferring a 20% interest in this LLC that owns this building, again, I'm able to deeply discount the value of what I've sold. That 20% is not marketable. I can't go to Andrew and say, hey, do you want to buy a 20% interest in this LLC? You can't vote on anything. You have no say about anything. And I control everything, and you have to be my partner in owning this real estate. And at my, at my will, I can do whatever I want. He's not going to pay me 20 cents on the dollar. So we're able to steeply discount the value of what I'm transferring, and I get an annuity in return. So I'm not using any of my estate tax exemption because I'm getting value dollar for dollar. I select a term of years in which I get this annuity back over time, so I'm being paid. And in a lot of cases, people are willing to transfer an asset to their children, but they really don't want the cash flow to end for them quite yet. They still need that money to live, or they want that money. We can kind of back into an income stream for them where they're getting an annuity payment each year, which is paid via the income stream from that property. So if I have an apartment building in the Bronx, all of my tenants are paying rent, let's hope, and they're transferring the rent to the entity, or at least 20% of the rent is going to this trust. And now the trust turns around and pays me my annuity. So the money goes around in a big circle, but effectively I'm getting property out of my estate at a discounted level. I'm still getting paid a cash flow, and I'm not using up any of my estate tax exemption in structuring that. The caveat there is, again, I've got to survive the term. So I can't say spread these payments out over the next 50 years. I may not survive the 50 years. And if I don't, we go back to zero. It's as if we never did this. So you have to select a term that you feel that the person is likely to survive. And then there's a small interest rate that's added. Now, this is where these planning strategies really shine, because the interest rates are so incredibly low. I've never seen anything like it before. So you can, as long as the income stream from that property outperforms that, typically, I mean, right now it's like under 1% interest rate. As long as I can sell the property and the property can outperform in terms of growth and income, that 1%, I'm going to get some property out of my estate for free. So you'll often see these types of strategies done where we do a few of, we call it a ladder of grats, where we'll do different terms and different percentages of the same entity. I'm going to take 20% of this building in the Bronx. I'm going to put it into a 3-year grat, and then 20% in a 5-year grat, and 20% in a 7-year grat. There's a lot of strategies that we can do, but in the end, I'm going to be able to get value out of my estate into a trust for my spouse or for my children, freeze the value of that property, and not use any of my estate tax exemption in the process. And this strategy, is as complicated and strange as it may seem, is actually prescribed in the Internal Revenue Code. It's an actual statutorily blessed estate planning strategy. So I didn't write it. Another estate planning lawyer didn't come up with this idea. This idea was actually created by statute by the federal government. So it's something that it's not going to be audited. As long as you're using reasonable valuations, you should be able to do it. And, you know, we kind of view this as hitting doubles all day. You know, you can do this type of strategy with the right type of asset, very, very low risk, if any. And you're definitely going to reap a reward as long as the property continues to produce income and or increase in value over time. More of a triple or a home run is this mouthful of words called an installment sale to an intentionally defective grantor trust. And that's just a fancy way of saying I'm selling something to a trust. So take the GRAT, and instead of doing, transferring property in exchange for an annuity, we're changing it up a little bit. We're changing the strategy a little bit to try to get some additional advantages. We're still able to apply discounts. We're still freezing the value. The interest rate that's applied to these techniques, it's actually lower than the rates for the GRAT, which used to be significant. Now all the rates are so low, all of these strategies are performing phenomenally. You don't have to survive the term, so we could make that promissory note a little bit longer. So if the property is not producing a lot of income, we can stretch it out over an extended period of time and still be able to satisfy the note payments. And we can even make those note payments interest only. So we're not even paying off the promissory note. We're just kind of treading water, but locking in that discount and that frozen value as of today's valuation, where the value might go up in the future. It also has some additional advantages as far as being able to plan for multiple generations. That's always what estate planning attorneys are trying to do. We not only want to create a legacy for your spouse and for your children, but we would love to see these assets go on for your children, your grandchildren, your great-grandchildren, and ideally never be taxed again, right? Because the IRS wants estates to be taxed at every generation. So where you see a wealthy family, when grandpa dies, he's going to pass his assets to the children. The children are going to have them for a while, then they're going to die and pass it to the grandchildren, and we can tax it again. We're always looking to avoid that step and do multi-generational planning. You can't really do that with a GRAT for a bunch of complicated reasons, but you can do it with this other strategy. So it's kind of a variation on the same theme, taking investment real estate, reducing its value, and getting it out of one's taxable estate and saving ultimately on what the estate taxes would be. And this is something, the SLAT is something that we're hearing a lot about. This is something that we're doing all the time now. Because, and remember I mentioned that the federal exemption is right now almost 12 million, but it's set to come down to about 6 at the end of 2025. Most people that I talk to believe that will happen. The increase in the exemption from 5 million to almost 12 million was done under the Tax Cuts and Jobs Act by President Trump and a Republican Senate. And they were only able to get this as a temporary regulation. This was not a permanent regulation because they didn't have the votes to do it. Unless they're able to get more votes, this will either be temporary again, or it will just fall by the wayside and reduce back down to around $6 million. Because things are unlikely to continue to trend further to the right. Most people feel it's unlikely that the exemption will remain at 12 million, but more likely there won't be the votes for the temporary patch, and we could see the exemption fall down by default to that 6. So a lot of my high net worth clients are saying, well, I would love to make use of my $12 million exemption. I don't want to be faced with the fact that I now, am living after 2026 and I don't have it anymore. So what they're doing is they're creating this spousal lifetime access trust, and they're creating a trust for the benefit of their spouse and funding it with a full $12 million exemption, or $11.7 million exemption. They're taking $11.7 million worth of assets and dropping it into a trust. They can do that on a discounted basis, so we can apply all these valuation strategies and things that we talked about, but we're packing a trust with as much property as we can and locking in use of that larger exemption. And we've already received guidance from the IRS that they won't claw it back. So they're using that exemption now so that if the laws change in the future, they will have passed on more property. Now, the reason why it's attractive to put it into the spousal trust rather than the intentionally defective grantor trust or the the GRAT is because they're able to keep that money in their household. So they may not feel entirely comfortable with parting with that much money. It may make them uncomfortable that they're giving away that much to their children. But if we create a trust for the benefit of their spouse, theoretically, if we need the money back, we can get it. We can fund that. We can take a distribution. We can take income from it. We can even give the principal back to them if we need to. It would be destructive from an estate tax perspective to do that because they've used their exemption and now they're taking the property back. So these will be the last dollars that they would want to spend. But the spousal lifetime access trust gives them a safety valve to be able to get that money back if they, if they're completely, they realize that they plan too much and they need some money back. So it's a strategy that a lot of people are using now before the estate tax laws change. Again, scheduled to change at the end of 2025. Obviously, depending on how the next election goes, if things swing wildly to the left, we could see the estate tax laws change even sooner. So some people are looking to do this planning now because if we range into 2021, we could end up with a retroactive tax bill that causes that exemption to drop down, and now it won't be available anymore. So I'm putting the thank you up there, but I think we should hit the questions because we've got a lot of them. Let me actually pull down the share. Okay. I know that was a lot of information. I hope everyone got something out of that. But let's go into the questions. I'm going to hit them all, although some of them are not real estate, not trust and estates related.
First, yeah.
You want me to just do the estate ones,
Yeah.
or I can just queue them up and then we can discuss them in turn. Okay, Andrew?
Sure.
Okay. So question number one: when do you think we'll be able to resume showing apartments?
That's a great question. I don't know. Hopefully the ban doesn't get extended. We'll see. We'll see. Definitely be careful, right? Don't do anything you're not supposed to, right? I'm sure your companies have told you that, but we have to be creative in the right way, whether it's, supers doing walkthroughs or doormen, but right now we can, and we don't know for sure. I know there's discussion on extending May 15th in the city, so we have to be careful. This one might be a good question for you, Alan. Will SALT be reversed?
That's another political question. I know Governor Cuomo has been pushing the president to make a change there to give some relief to New York taxpayers. But I think that's a question that's probably above anyone's pay grade here on the Zoom call, unfortunately.
And we certainly hope so. That would be huge for New York and New York's real estate market. Beyond city and state and federal taxes going up, what do you think will happen with long-term capital gains taxes? Again, Alan, you might want to weigh in on this, but I think this is another crystal ball type question. I mean, revenues are obviously down across the board, and government's going to have to figure out ways to raise additional revenue, both city, state, and federal. But long-term capital gains?
Yeah, I don't, that's a great question. It's hard to tell. I think there'll need to be a switch in both the president and the House and Senate to see a big tax change. So for the moment, I think the assumption is that nothing will change. It's quite possible, but most likely it won't. The thought process on when we'll be allowed to start showing and when activity in our city will get going is going to be dictated, initially May 15th, from what I hear, they're going to open upstate. Here in New York, it's going to be essential services and a very slow opening. So one would think that between May 15th, June 1st will probably be a time that things start to open up, with some people going back, some people showing, and hopefully by June 1st and after, things swing into some type of normalcy or the new normalcy, so to speak.
Right. This one seems to be for me. For estate planning purposes, should real estate be purchased in a family trust or an LLC? Does a family trust have more transparency than an LLC? So those things are not mutually exclusive. In most cases, investment real estate should always be purchased in an entity for creditor protection purposes. You want to segregate your assets out and separate them so that if there's an issue relating to one property, that those lawsuits and those issues won't pass through and end up a problem that someone will have to use their other assets or their other properties to pay for. So yeah, LLCs should be a no-brainer in most cases where you're buying investment real estate. A family trust is really a strategy, and what I think you're probably talking about is a family limited partnership or a family LLC. And that's a strategy where you're giving away interests in property in order to reduce your estate taxes, number one, and number two, kind of bring the family into the into the real estate business, into the management and ownership of family real estate. So, there may be various types of trusts and family entities that we would use for estate planning purposes and for business succession purposes. And that may involve both LLCs and trusts. So I hope that's helpful. Do you expect estate taxes to go up? If you ask me, if I'm looking into my crystal ball, again, nobody knows. I do expect, where you're dealing with a situation where, if people on the left do one thing, this will happen. If people on the right do another thing, this will happen. And if they can't agree and nobody does anything, this will happen. I think the thing in the middle happens. And by default, what's going to happen is the estate tax exemption will decrease and therefore drag a lot of additional people into having taxable estates and paying estate tax. So I do expect that in the future, estate taxes will affect more people. And certainly if a progressive Democrat is in the White House, I guess Bernie's out now. But if the agenda in the White House and in the Senate and the House is a progressive liberal agenda, then estate tax is a very progressive tax because it affects the wealthy exclusively, and it's very good for asset redistribution. So you'll have to watch the political environment to know for sure. Any sign that high-end buyers will jump back into the water?
I think there's a chance, right? Because New York City, these properties are bricks and mortar investments, right? With the stock market, skeptical. It's a nice place to, diversify and put some of your money, and you would assume, especially on the new development side, there are going to be some deals out there, right? So I'm sure you're starting to hear, I'm sure people are starting to think about, opportunities and if they can get a quote unquote steal or, I remember even before this all came about, with the new development, especially high end, the developers are saying, make us a deal, make us an offer, right? So now I think that'll be even more exaggerated. So I think high end purchasers may be, roaming for sure.
Okay. Are we seeing managing agents allowing minutes to buildings to be emailed to attorneys for due diligence?
Yeah, 100%. I mean, it's been 6 weeks now, right? So people have kind of loosened up a little bit in the beginning. There was a lot of resistance. Just if you are getting resistance, understand managing agents, implement the building's rules, right? They don't set the rules, the board does. So if you have a sale or even on your purchase side, unpeel it a little bit. Obviously be sensitive to the environment, but it's okay to ask the questions, who's making this decision? Why can't we get access to them? It's become the new norm for sure. So you would hate for something like that to impede your deal.
Yeah, and likewise in terms of co-ops and trust ownership, I think we had been seeing more and more that buildings were allowing for trust ownership of co-op apartments. Again, there's really no legal reason why they should have a problem with it. It's just really a stretch out of their comfort zone, just like emailing out copies of minutes. So I think it's, hopefully a time where managing agents are taking stock and buildings are taking stock and realizing that certain accommodations can be made, and it helps to make a property more attractive, more flexible for people.
When you see Lydia's question, I guess this is a little bit of a loaded question. Can a relative not part of a trust stop the sale of a property if they're living in the property illegally?
Okay, so yeah, I mean, look, just like any other landlord-tenant problem, you know, if you've got an occupant in a property that needs to be removed from the property, whether they be a relative or a squatter, you know, they don't have a legal right to, you know, to the property or anything like that, but they have to be dealt with. So, you know, we encounter issues all the time with, you know, with family members that, are, you know, don't feel they're being treated fairly, or they're being inconvenienced by the fact that, you know, the estate needs to be wrapped up and properties need to be sold and people need to move on. So they don't have a legal right to do anything, but as a practical matter, they can certainly create a problem. And then, Andrew, do you see the question on the top there from June?
Yeah. So June, first I would start with this caveat. You know, you hear about it because it's a sexy discussion, but most deals are not being renegotiated. I think a very small majority of deals are being renegotiated. I think people are asking, right, because, you know, they feel like they need to. But you have a lot of sellers that say, listen, we're not reducing the price. We'll be patient. We'll close after this, you know, when the governor opens up the city or our state. We're not reducing the price. We're in contract. You have no legal, you know, right to get a reduction. But the answer to your question, the deals that we are renegotiating, anywhere between 1% and 10%, I'd say the bulk of those are 2 to 4% reductions. I had, you know, a deal, actually when it first started at 3.5, reduced 10%. The seller was happy to, you know, reduce it by 10% and then move on. But I think some parting words on the estate planning end. Well, I imagine many of you have some extra free time on your hands these days. And whenever we give these discussions to the real estate community, especially brokers, estate planning professionals, just like accountants, financial advisors, can be a huge resource to you for business opportunities, right? We're dealing with life events, buying and selling properties, divorce attorneys, for example, unfortunately, you know, death, marriage, you know, all these attorneys like us that deal with life events may be an opportunity for you to connect with and maybe potentially get business, right? They deal with clients, you know, when life events happen, and that necessitates the need for sometimes selling property, even buying property. So if I were you, I'd reach out to my family, my friends, my spheres of influence, and ask if anybody has estate attorneys, and maybe set up a Zoom conference with them and just start to collaborate and get the conversation going. I think it could be a great time well spent in today's world for sure.
Yeah, and I think, and just kind of wrapping up, you know, I know that there was a lot of technical things thrown at you, and obviously it's not expected that you're going to go out and draft an intentionally defective grantor trust. I think the takeaway here should be, you know, just knowing that there's a lot of different opportunities out there, a lot of value that can be added to your high-end real estate clients, and, you know, being able to connect them with the right information and knowing enough to be conversant in these things, I think really differentiates you from your competition and enables you to provide additional value that others may not be able to provide. So hopefully this was helpful.
I have one more question that I just posted there.
Followed by the pound sign.
Have we seen changes in leases being negotiated now? What clause covers if the tenant dies? What are the obligations of the estate? So as far as new leases, you're making sure that people, you know, the tenants can move in, of course, and if there's a delay in moving in, then maybe they have the ability to get out of the lease, right? If there's a holdup. But as far as a provision, if the tenant passes away, yeah, I don't know let me look into that. Let me speak to my landlord tenant colleague and we'll get back to you on that. For everybody on the line still, we have a landlord tenant, you know, specialist. So I'll ask him about that provision. All right, so we're going to wrap up. Thank you, everybody. Thank you, Nick.
Andrew, Alan, Jordan, thank you so much. This is incredibly difficult and unique content. So we really appreciate your time and expertise today. Everyone else on the line, to the extent you have additional questions, don't hesitate to reach out and and send along your questions either direct to the folks that spoke today or to us on the NYRAC team, and we'll be happy to get those over to them. Stay safe, everyone. Thank you all so much, and we'll talk soon.